I'd like to call the Standing Committee on Justice and Human Rights to order. Being Monday, February the 5th, 2007, we will renew our study on the judicial appointment process.
We should leave, but I mean, it's televised. We should leave.
I'd like to ask the media if they wouldn't mind leaving now with their cameras. Appreciate that. And before us, as noted on the agenda, the Honourable Rob Nicholson, Minister of Justice, will be testifying. And he has two Department of Justice officials with him, Donald Buckingham, Judicial Affairs Advisor, and Judith Bellis, General Counsel. So, Minister, if you would, I'd like to thank you first for appearing, but if you would like to begin, you have the floor.
Thank you very much, Mr. Chairman. Je vous remercie de ma...
Thank you for this invitation to appear before the House of Commons Standing Committee on Justice and Human Rights concerning the federal judicial appointment process.
Our Canadian democracy is strong in part because of its constitutional underpinnings, its respect for the rule of law, and the mutual respect extended by each of the three parts of government, the legislature, the executive, and the judiciary, one to the others. With respect to several matters, the three branches have interrelated but distinct roles to play. This is particularly the case with respect to judicial affairs. Once the Governor-General signs an order in Council naming a person to the federal judiciary, he or she enters the judicial branch of government and enjoys the rights and responsibilities accorded to the judiciary, independence and security of tenure, to name but two, outlined under Canadian constitutional law. However, under the Constitution Act of 1867, Part 7, the legislative branch and the executive branch of government also have fundamental roles associated with judicial matters. Under Section 101 of the Constitution Act of 1867, Parliament is charged with the constitution and maintenance of our federal courts, as well as the determination of the salaries of federally appointed judges. The subject matter debated by Parliament and the passage of Bill C-17 in December of 2006 was an exercise of Parliament's competence in this area. The executive branch has been charged under Section 96 of the Constitution Act of 1867 with an important responsibility with respect to judicial affairs, the appointment of federal judges. This prerogative remains unchanged since 1867. With the Minister of Justice tasked with the responsibility of making recommendations to the federal cabinet for approval for the appointment of individuals to the federal judiciary. Constitutionally speaking, this legal power represents the heart of the federal judicial appointment process. As of February 1, 2007, the Canadian federally appointed judiciary consists of 1,054 judges, 825 of them acting as full-time judges, and the remaining 229 acting as supernumerary judges. The latter, of course, are those judges who, by virtue of the Judges Act and recent amendments thereto, have been able to elect to move from their full-time function to a reduced load given their prior service to the Canadian judicial system. All of these judges must retire at the age of 75. Thus, there is a constant turnover of judges with ebbs and flows requiring executive action in the appointment of new judges to replace retiring ones that unfortunately died in office and those electing supernumerary status. It's the responsibility of the Minister of Justice to make recommendations to the Governor-General through Cabinet to name individuals to these vacancies. The timely filling of federal judicial vacancies. When this government took over after the last general election of January 2006, there were 23 vacancies for federally appointed judges. This government has and will continue to proceed with all due dispatch to fill existing vacancies. Since January 23, 2006, 58 judges have been appointed, 20 in Ontario alone. This is a respectable achievement, given that in the entirety of 2004, for example, only 41 federal judges were appointed in the whole country. Still, I acknowledge that as of February 1st, 2007, we have 45 vacancies for federally appointed judges. It's important to note, however, that a full two-thirds of these have arisen since the coming into force of Bill C-17 on December 14th, 2006. That bill, as you know, provided federally appointed judges with new options for electing supernumerary status. Thus, the vacancy list, which was reduced to just 15 prior to the coming into force of Bill C-17, almost instantly tripled in size, the direct result of 30 judges from across Canada having elected supernumerary status under the new eligibility rules. I am committed to filling these vacancies in a timely manner, as was my predecessor, and will continue to instruct my staff to assist me in preparing recommendations for Cabinet approval for the appointment of new judges. Depuis 88, le ministre de la Justice a...
Since 1998, the Minister of Justice has been assisted in preparing recommendations for Cabinet approval for the appointment of new judges by Judicial Advisory Committees, JACs.
Despite the fact that the administration of candidate applications and the operation of the JACs have continuously been administered by the Office of the Commissioner for Federal Judicial Affairs since 1988, structural changes to the JACs themselves have been a fairly constant feature of the JAC process. Over the past 20 years, changes to the JACs have occurred in 1991, 1994, and 1999, always with a view to creating a process that provides the Minister of Justice with advice on the merit and legal excellence of candidates aspiring to judicial appointments. In November 2006, my predecessor announced changes to the process which would better assist the committee in providing assessments of potential candidates to the Minister. Changes were made to the composition of the JACs and to their operations, but the same fundamental purpose of assessing candidates and advising the Minister as to their suitability for the federal judiciary was maintained. Now, with respect to the composition of the JAC process has always sought input from a broad range of stakeholders. These stakeholders have, since 1988, been represented by men and women whom the Minister of Justice selects. Stakeholders from the Law Society in each province and territory, the provincial branch of the Canadian Bar Association, the judiciary of a province or territory, the provincial's Attorney General, and the public have in the past provided the Minister of Justice with advice in the form of assessments of potential candidates for appointment to federal and provincial superior courts. One of the November 2006 changes to the JAC process provides the opportunity for representation from another important community. A voice of the law enforcement community, a community no less implicated in the administration of justice than judges and lawyers, will broaden the basis of examination of potential candidates and contribute a fresh perspective of the competent and qualified individuals recommended to me for appointment to the bench. This change, implemented by my predecessor in November of last year, broadens the base of stakeholders who will contribute to this discussion and assessment of competence and excellence required for the appointment. Now, from an operational perspective, the 2006 JACs will continue to assess candidates and report to me on the quality and merit of candidates for appointment to the bench. Almost invariably, the assessment of candidates by the JACs results in a consensus finding and a recommendation to me. Thus, voting on the merit of a candidate rarely occurs. If it does, the results of that vote are recorded on the candidate's file comment sheet, which is directly relayed to me with each candidate's file. The outcome of this vote and the comments relayed to me from the committee would be taken into consideration when I decide whether to recommend such a candidate for judicial appointment. Another change announced for the 2006 JACs is to make the judicial nominee the chair of the JAC. As a consequence, the judicial nominee will have significant control over the oversight of the flow of discussions and manage the operation and expectation of assessments of candidates. In rare cases where a vote is required, the chair will abstain unless his or her vote is required to break a tie. Taking into account the important directive function of acting as chair, I do not believe that the judicial nominee has any less influence in the 2006 JACs than would have been the case under earlier JACs. A final operational change that was announced in November was the elimination of the highly recommended designation that might be given to a candidate. Like other aspects of the process, the designation recommended and highly recommended have not always existed. I remember a time when the JACs were required to assess candidates as only as qualified or unqualified. The designations unable to recommend, recommended, and highly recommended were implemented as a post-1988 change to the process. The highly recommended designation was unfortunately a designation for which no criteria were defined for the JACs to enable them to objectively determine when the designation should be awarded. One wonders if such criteria could ever be defined given the different practice contexts of Canadian lawyers. Experience also showed that the use of highly recommended was in some cases losing its significance as percentage rates for candidates receiving this designation varied significantly across the country. It's hard to imagine why, on a per capita basis, there could be a significant number of more highly recommended lawyers in one jurisdiction in Canada than in another. There also seemed to be a higher prevalence for the highly recommended designations for lawyers coming from larger firms than those from smaller firms or smaller cities. Finally, the comment sheet provided by the JACs for each candidate is more explicit with respect to strengths and weaknesses of a candidate than any one or two word label like recommended or highly recommended. All but one of the 2006 JACs have now been constituted, you'll be pleased to know, and several are already meeting to assess over 150 candidates from across Canada that are awaiting consideration of their application for a federal judgeship. I am confident that the 2006 JACs will continue conduct their examination and assessment of candidates with the same expertise, diligence, and conscience as prior JACs, and will forward recommendations that will permit me to make judicial appointments in a timely fashion from among candidates of merit and legal excellence. Finally, I would like to add a brief word about a subject related to the federal judicial appointment process, the outstanding requests for additional judicial resources. I expect committee members are also aware that a number of jurisdictions have expressed the need to have additional judges added to their courts over and above filling all current vacancies. I want to say that I'm prepared to give these requests serious consideration. However, I'm sure that all committee members would appreciate that the creation of additional judicial positions involves significant additional ongoing expenditure of public resources. It is therefore only reasonable but responsible to ensure that there is a clear objective indicator of the need for that expenditure. Therefore, my first priority is to get all the vacancies filled in a timely way, and as I have indicated, I think we are making significant headway now that the new judicial advisory committees are in place. Once those vacancies are filled, I will be in a position to better assess the overall needs of the requesting courts in light of their entire existing judicial complement. In addition, the government cannot simply act alone in providing additional positions even where their establishment is justified. Rather, amendments to the Judges Act would be required to provide necessary authority for the government to make those appointments. I would hope that all party support would be secured for the quick passage of such an amendment in the event that the case for additional expenditure of public funds is justified. Je vous remercie de votre attention et je suis...
Thank you for your attention, and I look forward to any questions you may have.
Well, thank you very much, Minister. I'll turn the floor now over to Mr. Murphy.
Thank you, Mr. Chairman. Thank you, Mr. Minister, for your comments. I guess I'll get right to the to the chase here. I think there's a case to be made that this gerrymandering of the Judicial Advisory Committees, the JACs, let's call them, is done to give the new government an opportunity to stack the committees, the JACs, and therefore influence the recommendation process unduly in a way not seen during the time of the Liberal government and certainly not even during the time of the of a previous Conservative government which you served in, mainly the Mulroney government. And I put it to you, just taking the case of New Brunswick, which I guess I know a little more about than the rest of the provinces, where there were 7 committee members. In short, 3 of whom were from the federal side. Let's put it that way. They were federal appointees, lay people in general. Generally speaking, they all came from different walks of life, and 4 from various stakeholders. Including the Attorney General, and I think we're all familiar with the makeup. What you have done here, what the previous minister, I guess, has imposed upon you, is an 8-member committee in New Brunswick with the addition of the police representative. I'm not going to ask about that, the merits of having the police alone visited on the committees, but I am going to ask about really the central issue for me, the concern I have, is with the chair being non-voting unless in the case of ties. You correct me if I'm wrong in the case of New Brunswick, but that would mean that 4 direct federal government, new Conservative government appointees effectively can outrule or overrule or outvote, if you like, 3 members from the rest of the legal community, let's put it that way. That's my first question. My premise on the question really is this, and it's the comments of the recent appointee who represented the police interests, so to speak, and that's a whole other question whether the chiefs or the rank and file should be represented. But the comments made by the representative were that there's nothing wrong with the judiciary. She's had no problem with the judiciary in her life as a police officer, and it would imply to me that there's no reason to change the system that has served us so well. I am wondering, by implication, if you think, as the new Minister of Justice, having served in this chamber as Parliamentary Secretary and now the Minister over a long political career, Mr. Minister, do you think there was something wrong with the quality of the judiciary meriting this stack the committee political gerrymandering proposition that's before us? Just a light question to start with, Mr. Minister.
I can't speak for the previous government, but certainly I can speak for the appointments that have been made under this government, and indeed in the years that I did serve as a parliamentary secretary and as a member of this committee and as a vice chairman of this committee, that I know that the criteria was always the highest quality of candidates, that judicial competence, first-class legal mind, people who were prepared to serve their country through sitting on the judiciary. And nothing has changed in that regard. I was a member of this committee when Raina Tishon, who at the time was Justice Minister of this country, proposed it. And it wasn't a question of trying to stack it in favor of the federal government, whatever that means. It was then, as it is today, an opportunity to get individuals who have a commitment to our judicial system and asking them for their input and their advice. And indeed, that wasn't the last word on the subject. That was in 1988. I believe there were 5 members. I was part of a government that changed that again to have a couple more individuals on that committee in 1991. And I believe the subsequent Liberal governments made at least 2 changes, I believe in 1994 and in 1999 as well. So over the last 18 and a half years since this concept was introduced, there have been changes, there have been modifications. With respect to the latest modification, which is adding a member of the police community, I think this is a positive change. Over the years, I've had the privilege of meeting with police association, chiefs of police, and when I was in private practice, meeting police officers within that forum, and I can tell you that they are as absolutely committed as any of us to making sure that our judicial system works, and having them, and that's the major change, Mr. Chairman. We have added another individual from the police community. I believe that it will work out very well, and again, I have no doubt about their commitment to our judicial system, and I think it will work well.
To Mr. Murphy and Mr. Menard.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Welcome to the Minister. You know that your appointment was a breath of fresh air But today, from hearing your presentation, we realize that essentially you intend to follow the line that was drawn so far, and that in positive and in negative sides of the issue, but I would say that from what we've heard, it's rather negative. This committee is very interested in having a high caliber of judicial appointees. You're going to have to explain to us how this is going to happen. There's going to be legislation, or how are you going to be able to amend the composition of judicial appointed advisory committees? Are these not just simply ideological considerations that you're following? Is this not an issue of the Conservatives wanting to stack the system, make it more right-leaning? Is this not an ideological step in nature? And who, apart from police officers themselves, are actually asking you, who is asking you to have police officers sit on these committees? Do you not see that there's something worrisome about this trend? Yesterday, I pulled out a press release on this very issue, and whether we stand on the left or right side of the issue, when we look at this new reform, there's no civil society support for it. Why? Because police officers should not intervene in the judicial appointment process. Would you be able to name one single country where there's a similar system which is prepared to do the same thing or has already done the same thing? Can you tell us what were the motives for this? Who's who's calling on you to do this, and what benefits should we be able to expect from this? And is this not simply an ideological purpose that you're looking for?
Thank you very much for that question. Going back to the first part of your question, these judicial advisory committees are actually already up and running, and I indicated in my opening remarks that with the exception of one, they're all up and running, and some of them have already had their first meeting. So this is already something that's taken place. So in answer to the second part of your question, whether this requires an amendment to a piece of legislation, it doesn't. These committees are set up to assist the Minister of Justice in his or her constitutional responsibility to appoint Superior Court judges. So therefore, because they are for the assistance of the Minister, there is no legislation governing this particular aspect, and nor would I think there would be one necessary, and I don't think anybody is suggesting that we change the Canadian Constitution. Now, that being said, I disagree with you about the addition that has been made of a member from the police community. I have found in my lifetime, and you may have had a different experience, but if you did, that actually would surprise me. The police officers that I have been in contact with over many years as a member of this committee, or as a parliamentarian, as a lawyer, were absolutely committed to the criminal justice system.
Who supports that? Who supports this type of reform when you're looking at civil society, for instance, those people who have written on the issue? Are you not worried about breaking the balance that lands there? My older brother is a police officer. Police officers have important work to do, but the administration of justice, I mean, you should understand the importance of the legislative, executive, and judicial branches. Now, you're creating an imbalance in this sense. There's something unhealthy about this. I understand the status quo stands, and I think this is really ideological in nature, what your motivation really is, and in fact, you would be going against this balance.
And I think this is a system that has worked well. And when I discussed this as a member of this committee with Ray Natish in 1988, there was no suggestion that this was the final word on it, or that this was going to be entrenched for all times. It was, I remember back in 1988, it was more of an experiment to try and get some input to the Minister of Justice, and there have been modifications of it over the years. I mean, with respect to the other part of your question, in terms of other countries, it's very difficult to compare. I live in a border community, and every couple of years I'm inundated from American programming of judges running for election. And how can we compare that system? I've studied the German Constitution. It's a very complicated process. We have what is known as the Westminster model, whereby in our Constitution it's the Crown makes these appointments and the person.
My question is, who's asking for this?
Vous le demande. J'essaie de comprendre qui vous demande ça.
Monsieur,
I'm trying to understand who is asking for this. I'm trying to understand. We're not talking to you about American model. Who's asking for this?
I tell you, Mr. Menard, the Minister of Justice, in an effort to broaden the individuals who are advising him with respect to his constitutional responsibility, deemed it appropriate and a step in the right direction. And so, over the years, various ministers of justice have made modifications because they want to get the best input possible. They want to get people who are dedicated, competent individuals, and this is another part of that ongoing process.
thank you very much, Minister. Mr. Comartin.
Thank you, Mr. Chair. Thank you, Mr. Minister, for being here. Let me pursue it along the same lines. I have to say that my feedback from the legal community in particular is that this is just another step on the part of the government to politicize not only the judiciary but now to politicize our police forces. And I think that's highlighted, and I don't know the last few appointments, but out of the first 8, there wasn't one who came from the police that came from the police chiefs. It all came from the police associations. And it's no secret that the chiefs of police, that association, has been more judicious in its assessment of crime legislation and how the criminal justice system should be dealt with, and the police associations have been. The gun registry probably being the highlight of their taking a different position initially than the police associations did. As a practicing lawyer, as a person who's involved in the legal system for your entire career, do you not see the serious risk you are perpetrating here of politicizing both the judiciary and the police associations? And at the very least, even if you say that that's not happening, it's not your intent, would you not agree with me that the vast majority of lawyers in this country and the general community see you doing just that?
I wouldn't agree with that, and I've made the point that it's very difficult to make generalizations with respect to the attitudes of people in the police community, just as it would be difficult and wrong to make conclusions as to what defense lawyers believe or what they are looking for. And so adding to this process in no way politicizes it, and I think strengthens the input that is given to the Minister of Justice. And so I think the process has worked well in the past, and I think it will continue to work, and I believe that that process will continue to work with another perspective or an additional perspective, and that would be a member of the police community. So I don't see that at all.
What do you say to, what do you say to the First Nations or women's groups who are saying, wait a minute, we use the system. Certainly in the case of First Nations are oftentimes the victims of the system. Why are we not given special consideration in terms of the input that we could give to judicial appointments?
Well, if that's a suggestion that you're making, Mr. Comartin, you're entitled to make it. But I have complete confidence that those individuals that are appointed by the Attorneys General across Canada will take into consideration that when they are making recommendations to the Minister of Justice in the exercise of his or her constitutional discretion, that they will take matters like that into consideration. And I have complete confidence that members of the Bar Association and in this case, the people from the police community, I believe they will take into consideration, and they have a responsibility when they're making recommendations to make sure that all interests in society will be heard and will be fairly treated. And that's the basis, quite frankly, of the judicial appointments process. We have to have individuals who have a fair outlook and that will understand that this country is diverse, that there are many opinions and groups that need to be heard and represented, and I'm quite sure that the judicial advisory committees, as constituted, will live up to that responsibility, as has others in the past. I have no doubt of that.
But certainly you're not going to suggest that the present composition in any way accurately reflects our communities, much as they do it, much more so, I'm sorry, at the provincial level. That the composition of our committees is heavily weighted towards the legal side and now bringing in the police. But people, the consumers of our courts, are not in any way proportionally represented on those committees at this time.
One of the things that we have to struggle with, Mr. Kilmartin, is to make sure that in the actual judicial appointments that those individuals and groups, I remember back in the 1980s, the early 90s, women were very much underrepresented on the bench, as indeed continues, and a push was made to make sure. And so we are.
We've been more successful, much more successful of doing that at the provincial level than we have at the federal level.
I don't have statistics comparing, and in terms of the judicial appointments that I have made or my government made, they extend back only to the last 12 months. And so for the appointments in the previous 12 months, I don't have any statistics in that regard, but it certainly is a priority, and certainly we want to have people who represent all communities. They have to see that on the bench, and I think that's only fair.
Mr. Kilmartin, Mr. Petit.
Merci. Bonjour, Monsieur Nicholson.
Hello, Mr. Nicholson. I have a question for you. Could I see my document, please? I'm sorry. On June 7th, 2005, there was a resolution from the House of Commons that stated, pursuant to the order adopted on June 7th, 2005, the House was moving to a vote on Mr. Marceau's decision. There would be a discrimination based on political opinion, which would be acceptable in the appointment of candidates to the bench, and that it is calling on the Standing Committee on Justice and Human Rights to create a subcommittee which would then study the judicial appointments process and make recommendations for reform in order to take political partisanship out of the process before October 31st, 2005. There were 157 that were for and 124 against this motion. You know who would have voted against it. Have you met this need, would you say? Mr. Murphy, Mr. Murphy asked a question about stacking the committee, at least this is what I seem to have understood. Last year, in 2005, there was a Chief Justice who stated that partisanship is not a condition to not appoint someone. The Bloc Québécois rightfully decided that things needed to change. I can't see why today they seem to be changing sides on the issue. As Minister of Justice, do you believe that the change that you are proposing could meet the requirements of this order of the House of Commons, which was actually reproaching the Liberals for being too partisan in their approach to this issue of judicial appointments?
I don't know if there's much point in me at this point attempting to analyze appointments that were made by the previous government or whatever motivations went into that, but I can tell you that, and I should point out to you, I'm not here proposing a new system. There already is a system in place that's up and running that was proposed and implemented by my predecessor. But I think I should be very clear about how these judicial advisory committees work. It's not a question, it's not part of our adversarial system. And in many ways, we generally think of decision-making in this country along adversarial lines. We can think of the House of Commons. We have the split between the government and the opposition parties. If you attend in court, you have the Crown Attorney or the plaintiff and the defendant or the accused. We are used to an adversarial system, and so we assume that is the way things are organized. That's not the case with the Judicial Advisory Committee. My experience at this point is that these committees overwhelmingly come to a consensus one way or the other. And it's not a question of having the government against any other particular group. These individuals work together, and I believe they do work together. And I think that we as Canadians can be very proud of the individuals who have been appointed to the Superior Court bench in this country. And we shouldn't apologize for it. And I don't think we should fret that somehow something has gone amiss, when in fact we have an excellent system, an excellent process, and that we have great individuals who have stepped forward to serve their country.
Mr. Petit, Mr. Bagnall.
No, thank you. And I've never said this before, but I'm absolutely very, very delighted you're in this position. I have a quick point I want to put on before I ask my question, just for your knowledge. There's an aberration in law that presently calls the justices in the territories a different name than Chief Justice. And the Premiers and everyone's asked you to change it, and the last minister said he would take that to the Prime Minister, and I hope you'll follow up on that. That's not my question, though. As formerly being responsible for democratic reform, I know you'd like things to be democratic. And so if this committee, as the justice representatives of a democratically elected parliament, were to suggest changes to the JAC procedure or reverse it to what it was, would you endorse those?
It seems to me it may be premature, Mr. Bagnall, at this point, that to do that when, in fact, we've got the process up and running. And certainly what could happen, any change to that process right now would probably delay the judicial appointments process in this country. And as you know, there is a number of vacancies that I indicated in my opening address that I would like to see filled. And so I would suggest to you that the process that is already in place, I think it'll work well, and I think it should have the support of all members around this table.
So you would never consider our input?
We never say never, Mr. Bagnall, but the system has worked well. And again, when this was first proposed to me in 1988 or discussed with me, it seemed to me an excellent process that the then Minister of Justice was implementing. There were modifications of it a number of years later, and I thought that was reasonable.
That's good. Well, yeah, the system has worked well, and I think that's why the opposition didn't necessarily want it changed. My understanding is under the system before you changed it is that a police officer could be appointed or a police representative under the lay positions. Was that true?
That is correct.
So then it's not true what you've said in that this purpose of this expansion was to broaden individuals advising the minister, or, as you said in your opening speech, provides an opportunity for another group because they already had that opportunity. They could already be on the committee.
Yeah. It's an additional perspective. There's no question about that. There's more individuals now giving input to the Minister of Justice on the exercise of his or her constitutional discretion. And for instance, we have represented the provincial's attorneys general. We could have always done that without having it formally part of it. But I think that's a healthy part of the process to have provincial attorneys generals because of their responsibility in the administration of justice in this country. So to designate an individual on that, I think is a good idea, and I think it can work well.
But the police could have always been involved before, so we didn't need this change to get them involved.
One of the positions could be any individual could be appointed by the Minister of Justice with respect to the appointments that his or her makes.
You know, I think the biggest concern is that people see the justice as independent from Parliament. And and of course you make the final decision, we don't quarrel with that, but don't you think at least having a commission that makes the recommendations, not having a majority of your appointments, would give the public more confidence that there's this separation between the judiciary and the executive branch of government?
I think the whole process of judicial advisory committees are a step in the right direction. And I don't think you or anybody I've heard, I'm not sure, would want a constitutional change from the present situation we have, which is that the Minister of Justice makes those recommendations that are eventually ratified by the Governor-General of Canada. Nobody is suggesting that the Constitution be changed. But in terms of getting input onto those appointments as to who the Minister of Justice should appoint, I believe it is a step in the right direction to have members of the police community to make that input. And I think it's a healthy part of our exercise. And again, I don't accept the premise that there is some sort of combative or adversarial role that takes place within these committees. My understanding of it is that they work on a consensus basis, and I believe that will continue.
Mr. Bagnall, Mr. Vachon.
Thank you, Mr. Chairman. First off, I'd like to thank my colleague, Réal Ménard, who's willing to give me some of his time. I think it's important for me to speak at this point. I discussed it, and perhaps I'm one of the members who's got no legal background, really. And looking at this, I have to say, the idea of having a police officer sitting on the advisory committee, I'd read about it, but here I am now before the Justice, here with the Justice Committee, and I think it's important to state my opinion on this. I think it's not so much an issue of partisanship, unless the minister says we want police officers who are conservative leaning, and I'm not sure that's what the minister wants to say, but I think Mr. Ménard is right in saying it's about striking a balance. In society, you have the executive, the cabinet, the prime minister, you've got the legislative branch, the colleagues around this table enacting legislation, and then you have the judiciary, or the judicial branch. And these three branches evolve in their own ways, and I think that a balance has been struck in society, and when we start disrupting that balance in some way, it calls into question some basic notions and values within our society. We have to be careful. I understand that in terms of the executive, it's the minister that does choose who sits on these committees, and there needs to be no legislative sanction to allow the minister to move to change. But now, here we are at the legislative level, trying to maintain some balance in society. As far as I can see, the problem lies in the judicial side. You've got, on the one hand, the judiciary, and then you've got the law enforcement community. The police officers carry out investigations, and in some provinces they may lay charges, or the Crown may lay a charge. Often I've read court decisions and found that it's important for there not to be a conflict of interest when a judge makes a decision. It is also important for there not to be the appearance of a conflict of interest in a ruling issued by a judge. If you allow police officers, even though they may hold minority status on a committee, if you allow them to have their say on the appointment of judges through these committees, advisory committees, then I think then it does touch on the issue of an appearance of a conflict of interest. I'm not saying the judge has to say, oh, well, there was a police officer on the committee and he was supporting my appointment, and so I am beholden to him. But there is this issue of that perfect balance that exists today. And, Mr. Chairman, that is, I think, where the problem lies. And I personally would like a bit of more of an explanation on this. I would like police officers to continue carrying out their investigations in some provinces, laying charges, and the guy who knows that he's being charged and is innocent, well, that individual wants to make sure that the judge who's listening to, who's hearing his case, does not owe anything to anyone other than the people who appoint him, yourselves and the executive branch. the cabinet. So I need some reassurance on that. Because here you're opening the door to the appearance of a conflict of interest. If we want citizens in Quebec and in Canada to trust the legal system, we shouldn't be mixing the police law enforcement forces with the judiciary. These types of decisions could lead the average citizen to say there's something wrong in society.
Thank you very much for your comments. We have members of the judiciary on that committee. In fact, they will chair that committee, and I think that's a healthy component of the process. And I believe that police officers, members of the police establishment, will make a positive contribution. I don't see this as a group of individuals at odds with each other. I have known Crown's attorney in my life. I have known judges. I know members of the defense bar. I know members of the police establishment. And for the most part, and almost invariably, they have the best interests of the judicial system at heart. And you, I'm sure, are aware, as I am, of police forces that have innovative concepts in dealing with the difficulties that they experience on a day-to-day basis. And so I don't look at it that they are at odds with any particular component of the judicial system. I firmly believe that everyone involved with our judicial system, the different components are there for the best interests of the rule of law and our judicial system in this country. And I believe that you will see that. And you'll approach me someday and tell me, I think that it really worked out well to have members of the police community, that they have made an outstanding contribution to the process, and to that process made an outstanding contribution to their country. So I look forward to that opportunity, and I say to you to please keep an open mind about this decision that has been made, and because I think it's in the best interest of the administration of justice.
Thank you, Mr. Vachon. Mr. Nicholson. Mr. Moore.
Thank you, and thank you, Minister, for being here today. We appreciate your appearance. You mentioned in the past that these advisory committees are in place to provide a list of recommended, it used to be recommended, highly recommended, or not recommended to the minister. You had alluded to some changes that were made in the past. So there seems to be, on one hand, some thought that we had a absolutely perfect balance on these advisory committees before, but in fact, there has been changes done in the past. Can you speak just a little bit about some of those, and to the suggestion that now we go back and somehow narrow the advice that you can get, as the suggestion is by taking the police off the advisory committee, that suggestion to narrow the input from the broader judicial community into the advice that you get. Can you talk a bit about how what value there is to having a broader spectrum of advice on these committees?
Time that an individual has to make a decision to get input from a number of areas or a number of individuals, I think is a healthy thing. There have been, I believe this is the fifth modification in a little over 18 years of the judicial advisory committees made by a couple of different governments. And again, going back to their creation, it wasn't written in stone. It wasn't to be the last word. If I remember the conversations, and I think I do fairly clearly. And so there have been a number of modifications, and each of those modifications can be judged as to whether they are successful. But it seems to me getting a number of people, a number of groups that have an absolute commitment to the best interests of our judicial system is healthy, and I certainly am one who looks forward to the input from them. It's a huge constitutional responsibility to appoint judges to the Superior Court. Expanding that group of individuals who are able to provide advice and are willing willing to provide advice, I have to believe is a step forward.
Okay. Thank you. Can you speak a bit, Minister, about the change to eliminate the highly recommended category? And you did mention in your speech that there's some blurring of the line between recommended and highly recommended, and perhaps inconsistent application. Can you speak to how that's perhaps going to improve your ability to make these decisions by having simply not recommended and recommended?
I can understand why the distinction between the two recommended categories were eliminated. It was very uneven, the recommendations that we were receiving across the country, that in some provinces you would get a majority of those recommended also came as highly recommended. In some provinces, a fairly small minority of lawyers received the highly recommended designation. At the same time, it was noticed that you were much more likely to get a highly recommended if you came from a larger law firm or one of the larger cities across Canada. I'm at a loss to explain that that would be the case, but I'm not at a loss to make the point that people who come from small communities and small law firms are just as qualified to serve on the bench in this country as those from larger firms. So in as much as there wasn't any objective criteria to say when a person is highly recommended as opposed to just recommended, it was deemed appropriate to eliminate that particular category.
Thank you.
Thank you, Mr. Moore. Ms. Jennings.
Thank you. How much time do I have, Chair?
Approximately 5 minutes.
I'll be very brief then. My first question is, did you or did your predecessor consult our judiciary, our Canadian Bar Association, prior to changing the composition of the committee to change it from 7 positions to 8 instead of 3 appointed by the federal government to 4? Was there prior consultation? Because my understanding, and you've made the point very well, over time there has been changes, modifications to the way in which the federal government comes about to appoint judges, and many of those have been very welcome.
Yes.
My understanding is that in most of those cases, the government actually consulted the judiciary and the Bar Association before moving forward to make those changes. So that's one question. Second question, you've said that of the 13 JACs, as you call them, Judicial Advisory Committees, 12 are up and running, if I'm not mistaken. Yes. So you've gone forward with the changes that your predecessor made, which was to increase from 3 to 4 the number of members appointed by the federal government, and one of those 4 members is a member from law enforcement. I would like to know how many of the 12 members of law enforcement come from the Canadian Association of Police Chiefs, are actual high-level, high-ranking police officers who have the managerial skills, who are there to put into place performance evaluations, procedures, you name it, operational, and all of that. How many? Another question is, you've stated on the one hand that you don't really have any statistics about the appointments of the government preceding you, but in your response to Mr. Moore, you've talked about how the number of highly recommended appeared in some provinces to only come from large firms, whereas in some provinces that wasn't the case. So I'd like you to bring forth all of the statistical information that you have, without the names, obviously, of the recommendations that have been made in the past under your government and under the previous government over, let's say, the last 5 years. From the 13 JACs, how many were highly recommended, how many were recommended, how many were not recommended, and where those lawyers came from, which city. Was it a large city? Was it a large firm? Was it a small firm? Was it a sole practitioner? You don't have to give us the name, so no personal information will be violated. You've made those points several times in your responses to members of this committee, so you obviously have this information. I would like you to bring that send that information to the members through the chair. And I will leave it at that. Thank you.
Please, the minister will respond.
Going back, I think I've got the list, Mrs. Jennings, and I'll go back to the whether you first of all said, did I consult? No,
or your
I wasn't. In terms of my predecessor, and you made the point that previous justice ministers consulted widely on these. There has been, it either have or they haven't. The first time in 1988, there was extensive consultations. In 1991, the decision was made by the Federal Minister of Justice. There were two changes to the process under the Liberal administration. I believe there was consultation on one of those cases, and on the other cases, the decision was made by the Federal Minister of Justice.
Thank you. Did you or your predecessor
And in this case, this decision was made
change?
by the Minister of Justice, the previous Minister of Justice.
And did he do any prior consultation?
I can't speak for him, Mrs. Jennings, but my understanding is he made the decision. And how he arrived at that decision, I'm not in a position to say.
Well, I think that if you would read some of the newspaper reportings and the statements of the Chief Justice, Beverly McLaughlin, Chief Justice of the Supreme Court of Canada, when your predecessor made the announcement that he was going to change the composition, she actually rebuked him publicly for compromising the independence of the panels, or the JACs as you call them, and the fact that there had been no prior consultation. That's public knowledge. So how can you, as minister, who was the House leader at the time, therefore responsible for guiding the government's agenda in the House, not be aware of that? But I would ask you to move on.
Again,
the question of the
Jennings,
are there police chiefs
I
on
indicated
any
the
of the
decision
JACs?
was made, as is the prerogative of the Justice Minister. That
Yes.
decision was made by the previous Justice Minister. And again, the history of this is that sometimes the ministers of justice have consulted widely or narrowly, and it's up to each individual minister of justice.
You're correct. I just wanted to know
with respect
whether or
to
not he had.
where appointments come from, you made the statement that you quoted me that the highly recommended appointments were only coming from large law firms. No, I didn't say that. I said there was a tendency that was noticed that it would be more likely that a larger firm from a larger community would be highly recommended. It was not necessarily exclusive, but there was a tendency in that regard. With respect to the statistics, by all means.
Minister?
Order, Ms. Jennings.
Yes.
Can you let the minister finish and then?
Well, the minister is not actually answering the specific. I did not say that he made that statement. What I said was that in response to Mr. Moore, he made the point that highly recommended tended to come from.
Okay.
So I'm asking
I apologize.
for
I didn't
you to
actually hear the word tended. The way I heard it, and that could be my fault, you said that I said that they were coming from, and I believe there's a tendency. And if I didn't make that clear, I want to make it clear.
Thank you. But the point is, whether it was you made a categorical statement or you said tended to come from, it would have to be based on some fact. That would mean that you actually have some statistics on the issue in order to say it tended or it did. You're saying you said it tended. You have some facts. I'm asking you to provide
I've not made a statistical analysis of it, Madam Jennings. Our observation of looking at these was that there was a tendency on both those counts. There was a tendency, for instance, in one province to have a fairly substantial majority of the individuals get the highly recommended category, where in other provinces there would be a very low percentage of the highly recommended. And I'm informed that information would be accessible for the, from the Federal Judicial Advisory Committee. I'm sorry, the Commissioner for Federal Judicial Affairs, and that he, and I'm sure a request by your committee, he would be glad to provide any information like that.
Thank you.
Ms. Jennings?
And third question, chiefs of police on any of the 12?
That's already up on, I'm sorry, it's already up on the website, and I would be glad to forward to you a copy of those individuals, but it is already public knowledge.
Thank you, Ms. Jennings. Minister, the time is actually concluded, but would you possibly avail yourself to us for another 10 minutes?
If that's the wish of the committee, I think
there are. I wanted to check with your time first, of course.
Well, do it another committee, but if we could perhaps confine it to 5 minutes, Mr. Chairman,
5 minutes.
I think that would be fine. Thank
Mr. Thompson, you have a question you wanted to pose, and then Mr. Lee immediately after. Move right along.
Okay. Well, first of all, I want to congratulate you, sir, on your appointment, and I wish you the very best in your tasks. I also am very pleased to hear you state that it's good to have the police input in these committees that you talked about. I certainly support that highly because they are part of our legal system. And another group of people that I'm quite concerned about, and I just going to throw that out there, and you can comment any way you like because it really isn't a question. Last week there was a decision made in a court in Calgary. Our chairman would be aware of that, where the victim was knifed to death and then his body was dismembered and scattered wherever. And the courts determined that it was a manslaughter and not a murder, and the victims are just highly upset over this. Immediately, people like myself, the phones start ringing. What are you going to do about these blankety-blank judges and their decisions in these types of cases? The group that I'm talking about are victims. There are thousands of victims out there who belong to organizations, they're grouped, they're working together to try and bring about a system that answers their pleas more than what has been happening in the past. No one can deny that we don't have a lot of people out there, those who pay the bill to keep the legal system going, would like to see some good justice, and they feel it's not happening. I'm just wondering if they shouldn't also have some input in some of these decisions. We talked about the judiciary, we talked about the police. How about the victims? I really put a high emphasis on their portion and their role that they play in this whole criminal aspect.
Well, thank you, Mr. Thompson. In the premise to your question, you mentioned a case. I don't make any comment about any cases that are before the court, but you would be aware that in the last election that yours and my party promised a victim's ombudsman, and I believe that is a step in the right direction in making sure that the rights of victims are heard within our system. I'm keeping it short, Mr. Chairman. I believe that Mr. Lee would like to have a question.
Well, thank you for the additional time, Minister, and congratulations on your appointment. You won't be a stranger to any of these issues. I want to first regret the decision of your predecessor not to consult with Parliament with this committee, which had done a significant amount of study on judicial appointments over the last few years. It was conspicuous, and it is regrettable that in the appointment of the judiciary, which of course is unelected, the minister couldn't have taken some time to check with Parliament to see what the lie of the land was. In any event, I also want a second congratulations to Mr. Béchamp for trying to articulate something here as a non-lawyer, which I know the minister will be familiar with, and it is this, that police could not be chosen as members of a jury. As between the Crown and an accused, the police are not impartial, they are not disinterested. And so I'm wondering how you respond to what I would say now, that the government has chosen to put police, when they're not disinterested as between the Crown and an accused, they put police on the committee that will play a major role in the selection of judges. And, you know, what about this concept of picking a judge who will decide on police cases in the future? And that, to me, gives an appearance of interest, of partiality. of trying to balance something that wasn't broken. So could you comment on that appearance articulated by Mr. Béchamp, restated by me, and please tell us what was so broken that it had to be fixed?
First of all, with respect to your comment, which is quite correct, you said that a police officer cannot serve on the jury, and I guess that's just one of the functions of the system of law that we have. That the lawyers who also serve on the Judicial Advisory Committee, none of them, of course, can serve on a jury, nor could the judge who sits on the case as well, or rather on the committee. So the judges themselves, of course, are precluded. So all the members on a Judicial Advisory Committee will never have that opportunity, and I believe it even extends to their spouses, if I'm not mistaken, but none of them will be because of their involvement, and I think you hit upon it. They're all very, very involved with the judicial system in this country. They all play different roles. I believe they all play an important role, but none of them will be able to serve on a jury. That being said, I believe that all of them have a positive contribution to make, and these committees have worked well, and it doesn't mean a committee can't be improved, and it doesn't mean that the minister can't get an additional input into the use of his or her discretion, and I think that's what we have here. I don't look at it as some people have suggested, some sort of an adversarial system, or that one group is more interested in the injustice in this country as opposed to another. I don't agree with it. I believe that in a sense we're all in this together, and certainly all those individuals who serve on a Judicial Advisory Committee, I believe, have and should have and will continue to have the best interests of the judicial system in this country, and I believe it will work very well.
Thank you, Mr. Lee. Thank you, Minister, for attending the committee. The meeting is now adjourned.